Hello, I'm Rebecca Arnold and I teach dress history here at the Courtauld Institute of Art in London. And I'm so pleased to be able to introduce Véronique Pouillard to you today as part of our Documenting Fashion Research Group events for this academic year. I've long admired Véronique's work. She's really a brilliant researcher and has shown how we can use business archives to enrich our understanding of the ways that fashion works, the way that designers have sought to clarify their status and the status of their designs in terms of copyright and intellectual property. Véronique is Professor of International History at the University of Oslo. She's a co-editor of the Oxford Handbook of Luxury Business, and very exciting, her next book, Paris to New York, the Transatlantic Fashion Industry in the 20th Century, is forthcoming in May this year, published by Harvard University Press. So we need to add that to our wish lists and tell our libraries to buy that because I'm sure it will be brilliant. Véronique also leads the ERC-funded project Creative IPR, the history of intellectual property rights in the creative industries. So I'm very, very pleased that you are with us, that you are able to attend this event, and I now hand over to Véronique. Thank you so much, Véronique, for being with us.
Thank you so much, Rebecca. Hello, everyone. Thank you, Rebecca. Hello, everyone. It's really a big pleasure to be here with you today to talk about the history of intellectual property in the fashion business. I'm now sharing my screen with you so you can see some images. This is an archives intensive talk, but I would like to start today with a question. Are the dresses designed by Madeleine Vionnet or by Christian Dior? Are these dresses, these garments, art? This question pertains to the definition of art itself. And here I'm going to build up on the writings of Bernard Edelman and Nathalie Heinrich, especially their book, Art in Conflicts, Art en Conflit. In this book, they explain how the activity of the courts can help us understand where art begins and where art ends, if it has a boundary. When art is difficult to define, we can approach it from the perspective of the sociology of law, and we can look at the courts. The works of Vionnet and of Dior have their place in the most prestigious museums. But Vionnet and Dior did not always necessarily define themselves as artists. Have they really claimed the status of artists? We don't necessarily have all the answers at once. And the writings of Edelman and Heinrich give us methods that we can then try to apply and enter the courts and see how couturiers there build agency in the courts. So this is what I'm going to do today. What I plan to do is to examine how the couturier used the courts. And I will focus on two examples. There would be many others. So of course, this is a difficult choice, and it's indeed a choice. One example takes place during the interwar period. It's the case of Madeleine Vionnet. Madeleine Vionnet, who succeeded in Europe, but to some extent, as we will see, failed in the United States. And then we will look at the case of Dior, and we will see how Dior managed to succeed both in Europe, in the US, and even to a global scope. So let us start with Vionnet. And the document that you can see here on the left-hand side is a photograph of a manuscript that is kept at the archives of the city of Paris. This manuscript is kept in a bound ledger, as you can see a little bit on the sides of the photograph. Such ledgers record all the lawsuits that have taken place in the small crimes courts of Paris. Each ledger contains worth of 4 or 5 days of lawsuits. So these are very long archival series. The court records in a chronological order, one after the other, a very broad series of lawsuits. One after the other, we find here lawsuits for vagrancy, for debauchery, for alcoholism, for petty theft, for sexual assault, and also for counterfeiting. They're all together there. And here, if you look up, I try to use my mouse here. You can see up here the name of Madeleine Vionnet on 30th December 1921. At that point, Madeleine Vionnet was a seasoned seamstress. She was still rather early in her career as a successful entrepreneur. And then we see another name under, against this name, Henriette Boudreaux, a seamstress, another seamstress that Vionnet was suing for counterfeiting. To prove the counterfeit, Vionnet had sent to Boudreaux a few days before the lawsuit a bailiff at Boudreaux's premises Rue Vignon that you can see here in Boudreaux's advertisement. Vionnet had sent a bailiff, and this bailiff seized several garments in Boudreaux's workshop. In court, Boudreaux was accused of counterfeiting, not the trademark, and we can see here on the two images on the right that Boudreaux's trademark and Vionnet trademark shared some similarities, quite striking in fact. But Boudreaux was accused of counterfeiting Vionnet's garments, especially a dress with 3 characteristic rows of fringe. This one may be a little bit earlier, but these type of garments were of the essence in the lawsuit and were shown in the court. Vionnet's lawyer, Maître Flack, won on the basis of 2 laws. The one was the right of the author, author's right. It's the French take at copyright, which confers a slightly higher moral right to the author than the copyright in common law, if you will. And the second law that Maître Flack used in putting forward Madeleine Vionnet's interests was the industrial property law, the law that protected industrial designs, designs made for industrial reproduction. So the 2 laws could be combined efficiently to protect the interests of Madeleine Vionnet. In court, Madeleine Vionnet had not come alone. She had taken with her several friends and colleagues. An actress, Cécile Sorel, who was a star at the time, a caricaturist, Sem, a fellow couturier, Jacques Fath, and all testified of Vionnet's creative genius. Henriette Boudreaux lost. She had to pay dozens of thousands of French francs in damages, and eventually that sum sent Boudreaux to bankruptcy. Vionnet won on the basis of author's right and industrial right, which legitimized her both as an artist, and this answer to Edelman and Heinich's question of what an artist is. And it legitimized also Vionnet as an entrepreneur. Vionnet was not the first to go to the court. Her former boss, couturière Marie Callot of Callot Soeurs, another famous haute couture house, Callot had done the same before her. But Vionnet was the first couturière who sued so many counterfeiters. After Vionnet won at the Paris court on 30th December 1921, it was not over for the day. Another lawsuit followed at once, Vionnet against Miller Soeurs. And Vionnet won that lawsuit too the same day. Miller Soeurs were well known, and copies of their works retailed in New York, as shown in the advertisement of the left-hand side of the screen. The second little tag from the left, if you see very well, shows the name of Miller Soeurs, and that's exactly those sisters that Vionnet sued that day. So Vionnet was the first to sue so intensively, and we'll see even a little bit more about that. And in so doing, Vionnet was pushed by the administrative director of her firm, Louis d'Angèle, the little portrait there on the left, the man with the mustache. And later on, d'Angèle was succeeded by another lawyer, Armand Trouillet, the second portrait there. Both men acted as Vionnet's right arm for administration and finance matter at the house of Vionnet. Both men also started associations of entrepreneurs that aimed to lobby the French state for a better defense against piracy. Vionnet also managed to interest other couturiers to her anti-piracy crusade. And this includes here Gabrielle Chanel, who is often quoted saying that copying was the best form of flattery, which is indeed something Chanel aired in various iterations in the media. But here, in this new series of lawsuits, still in the 1920s, still at the Paris courts, here against a couturière called Marcel Dormois, we see Vionnet on the left. If you look up on the page, I'll try to use my mouse to see if you can see this. Vionnet against the house of Dormois, and here on the other side, Gabrielle Chanel, also against the house of Dormois, at the same time, back to back in the same court. Couturiers then took up the habit of sewing together. These couturiers did not always win. Vionnet knitter did not always win, but from then on, going to the courts became rather common practice. Vionnet's strategies using the law were also very complete, shall we say, in a comprehensive manner. Fashion designers, indeed, even today, can use several laws to protect their work. We have already seen that there was author right or copyright in the Anglo-Saxon term, industrial design protection. There was also patent that would be more for technical or even scientific innovation. We can think about new fabrics, for example. There was, of course, the trademark. Another kind of law that could be used occasionally was trade secrets, protecting know-how. And yet another one was fair competition. That one was less used by Vionnet, but it will come back when we will look at Dior, who used fair competition to protect his own work. And here, all these documents are from Union Centrale des Arts Décoratifs, and you can see simply, it's probably many of them you've already seen, but how there was a systematical pursuit by Vionnet of identifying her work. The dress, that's a Vionnet dress, indeed, the logo, the trademark, the registered trademark, and the use of the trademark in all over, which today is used especially in America as the trade dress. Or we can think also about the use of all over logo and Vuitton bags, for example, right? And we see here how Vionnet interpreted that. We also know very well this, right? These are familiar images. Vionnet famously printed each of the labels of the clothes she issued from her workshops with her own thumbprint. And we see her on the right-hand side at work. A question is Vionnet's motives. Vionnet was very protective of her work, of her art. But she was also surrounded with lawyers, as we have seen, that were her managing directors and worked with her on a daily basis. There were also reasons of economic nature for her legal activity. Let's look at this. During the 1920s, haute couture did quite well in France, but it was much copied on international markets. American department stores had, here we see the image down left, American department stores, for example, had these twin models showing an original from Paris and a perfect American copy. In the United States, the culture was that cheap copies should be made for everyone in a movement of democratization of fashion. And that's the image you see upper left, right? This idea that a similar dress could be reproduced with, for example, more luxurious fabrics for every price point. The idea was that haute bourgeois or a stenographer could wear the same thing, that this was the essence, part of democracy. In this context, in the 1920s, Vionnet was the most admired French couturière in the US. It's impossible to know if Vionnet was also the most copied couturière in the US. But Madeleine Vionnet herself felt that American firms who were manufacturing and retailing fashion, these American firms were free riding on her creativity without giving back. And she felt certainly frustration from that. Vionnet tried different methods. She signed exclusivity agreements with one American manufacturer. Vionnet also in 1924 opened a branch in New York, hosted by a wider fashion conglomerate. And here, center, you can see this manuscript list that's in one of the three ledgers of the Vionnet firm kept at Union Centrale des Arts Décoratifs. And you can see listed all the dresses. The word robe there comes back again and again. All these dresses were embarked by Vionnet in New York for selling there, for reproduction there. Betty Kirk, historian Betty Kirk, of course, explains that very, very well. So we go back to Betty Kirk's great work here. But what happened is that Vionnet opened this branch, and we see also Vionnet was a superstar, right? Here's her portrait in the Taubé report by fashion forecaster Taubé, who regularly featured Vionnet's work. But the firm, the first firm that Vionnet had signed an exclusivity agreement with, that firm sued Vionnet in the US when Vionnet opened a branch in New York. The idea was that the firm that Vionnet had signed the agreement with felt cheated by having Vionnet now opening for herself. That's quite paradoxical, right? But then that means that Vionnet had to close this first branch in New York, and she came back to France. Back to square one, if you will. Overall, at that time, and to some extent until this day, by the way, we see that the French law offered higher protection, higher authorship to fashion design than the American law. I have made a very rough summary here in 2 columns. There's quite some work also by lawyers about it. You find some reference here. There's a bibliography at the end of the talk. But here we can see that in France, for example, copyright was protecting fashion. And in the US, even after the United States signed the Berne Convention in 1988, copyright in the United States still did not cover fashion. It covered a lot of other crafts, but not fashion. So that choice of which industries are covered by copyright is left to the nation states to this day. In France, too, industrial property could help protect fashion design more than this was the case in the US. And in addition, the trademark protection in France was also stronger, was more efficient to protect fashion design in the US, in France than in the US during the interwar period. This would change with the Lanham Act of 1946 that raised the trademark protection in the US. And that indeed had an impact of what came next for sure. So to sum up, the fashion designers in France benefited from high authorship, while in the US, they had to make do with a lower kind of authorship and of copyright protection. It took a new generation of French couturiers to settle successfully to open branches in the US. And coincidentally, this new generation also won the first cases against counterfeiting in the United States as well. The central person of this new chapter, indeed, is Christian Dior. Christian Dior opened his firm in Paris in 1946. That was 7 years after Vionnet had retired. Dior also opened a branch in New York in 1948 and soon became a global brand. And we have here, of course, the iconic Tailleur bar. And we know that Dior became very efficient in launching successful fashion revolutions roughly every 6 years, just to change the silhouette. A strategy that Dior perfected was to make one's own copies. That had been tried to some extent by Vionnet, Le Long with his edition line also during the interwar period. But with Dior, these strategies were perfected. What we see on the left-hand side is how his various brands, including Boutique, Original, Toile also, all his various brands were registered by the French Ministry of Economy. Other couturiers, of course, did the same. In the center, I've put for the record the brands of Nina Ricci. There are many other examples in the same archives. It's quite amusing to see how all the couturiers by the time have these different lines and name tags. Couturiers by then also had understood that they should be consistent with their names. Dior hired a lawyer, Elena Engel, in America to help him with that. And in the 1940s, at the very beginning, there was slight hesitation about whether Dior should have another name brand for the US. But Ellen Engel, lawyer, said, no, you have to be very consistent with the use of your name. And that resulted even in what you see on the right-hand side, which is Dior becoming a global brand in Latin America, for example, in Australia. Alexandra Palmer has studied this, and Tomoko Okawa as well, with the licensing methods. And these brands at once adapt to global markets, but also retain the attachment to the name. These brands are also registered both nationally and internationally. How was this possible? This was made possible thanks to a substantial injection of capital in Dior by the man at the center here in the top hat, who's holding the reins of the horse, Marcel Boussac, an industrial based in France who owned a textile empire, as well as firms in the media, in the household goods, everything from the textile to the washing machine, and the media as well, right? And Boussac could offer enough capital for Dior to really rise on international markets. The firm at Dior, and especially the administration led by Jacques Rouet, who was a management specialist, not a lawyer in this case, but a management specialist. Jacques Rouet carefully surveyed the American market, and you can see on the right-hand side this list of American retailers, and these lists in the Dior archives were full of comments about the robustness, the trust in these retailers to sell haute couture on the US markets. However, piracy remained a problem. And here I will quote Nan Robertson, writing for the New York Times in the late 50s. Quote, "This is a story about piracy. It's a 20th century kind of buccaneering that involves clothes and the men and women who make them. It is a tale of two cities, Paris and New York, and it explains how an American housewife or stenographer can buy a $25 copy of a $800 French dress less than 2 months after the original is shown in Paris." End of quote. Among the copyists were the so-called sketching services. The sketching services did not bother to make fake clothes. The sketching services instead sold drawings from the haute couture collections before the official release date. These drawings served as materials for firms who wanted to make copies of Paris couture without having to buy their passage to Paris and to gain their entry rights into the shows. Facing this situation in 1955, the House of Dior and 3 other couturiers, Fath, Lanvin, and Patou, held a press conference at Dior in Paris, Avenue Montaigne. And you see on the left-hand side top a photograph of this press conference. It's not Dior himself who speaks, but his managing direction. In these press conferences, via their managers, these couturiers announced that they were suing an American sketcher, Frederick Milton, in the Supreme Court of the state of New York that you see below. So it's the Supreme Court of the state of New York, right? Milton was well known from the couturiers. The couturiers thought that his business, and here you can see some of his sketches, that his business was unacceptable and illegal by leaking out their designs without an authorization. Milton sketches sorts of copybooks of this necklace, these sketches, copybooks of sketches as a subscription, and that cost $1,000 per year. But this was comparatively less expensive as going all the way to Paris for a business based, for example, in America. And the sketches were available very fast after the shows, cutting off, if you will, the novelty from the couture, going faster, right? We have this idea, concept, and problems of fast fashion that somehow are getting on the horizon here for the couturier. So this was a costly lawsuit. It was also a long lawsuit, initiated in 1955. It went back and forth. There were attempts by Milton lawyers to have the lawsuit dismissed on the ground that there was not really a reason for Milton to be accused in the law. And yet the lawyers of the couturier managed to keep it on the agenda. All in all, the lawsuit started in 1955 and lasted until 1962. The Paris couturier hired a prominent and expensive international law firm, Cleary Gottlieb Fredley and Ball, to document Milton's transatlantic activity. And as you can see in the center document here, this is an extract from the accounting of the Chambre Syndicale de la couture parisienne. The Chambre Syndicale stepped in to pay the important costs of the lawsuit. So the Chambre helped, and that's the tradition that we inherited from Vionnet, where several couturiers went together to the courts to sue. So there's really a continuity there. And here on the right-hand side, we see a note from Cleary Gottlieb explaining Jacques Fath at Dior why the costs of the lawsuit are so important, including documentation of Milton's action that had to be done extremely minutely. It's really kind of an espionage story that unveils here. And indeed, the lawsuit revealed a network of sketchers, including the lady here, Miss Kastner-Strober, who was Milton's aide. And this network copied Paris couture and made it available in record time in the United States. The French press, there are lots of clippings pertaining to that lawsuit. And here I have just picked up two good examples. The French press took this case very seriously, denouncing a conspiracy of thieves that spied on French know-how. Sometimes some accents that are a little bit nationalistic, also about protection of trade, pick up in these press reports. And obviously, this became an important story for couture of those years, also in terms of public relations, in a sense. So the lawsuit was eventually solved by a negotiated agreement in 1962. At that time, it's interesting to note that the four couture firms still existed, but that the four originator couturiers were all dead. So they were represented by the continuation of the management of the firm. The judges ruled that Milton had proceeded to use methods that were deemed to be unfair competition. In the United States, the judges could not use copyright law in a fashion case, as we have seen was used by Vionnet in the interwar period. So the judges had to work differently, right, and use laws that were available in the American legal arsenal in order to undercut Milton business, if of course that was what was considered to be fair. And what happened is that in this lawsuit, the judges carefully examined also the way that Dior worked, and they realized that the French couturiers were taking great care in designing, in enhancing the value of their brand, in the quality of their works, and to some extent also in protecting their work by setting some rules. And for this reason, the judges could use the law that forbade unfair competition in business. The idea was that business had to remain honest, and it's on these grounds that the Supreme Court of the State of New York in 1962 ruled that Milton had to cease his sketching activity. And here you see an extract of the last session of the judgment that was translated in French for the couturier, and you see all the names represented in the lawsuit here. So Milton was indeed ordered to stop his sketching activities. This lawsuit indeed did not build very powerful case law, because it didn't go to the place, for example, of pushing the Americans to include copyright in their law. And yet, the Milton case allowed the French couturiers to establish their intellectual property rights in the United States. It allowed Dior to have a strong foothold against American counterfeiting, something that designers before, for example, Poiret, as studied by Nancy Troy, Vionnet, as Betty Kirk has studied also in the interwar period, and many others had wished for without managing this in the United States. And this happened also even if today intellectual property is not internationally unified for fashion. So nations have a more or less important protection for fashion design around the world. What we also could see along these cases is that lawyers have become truly a part of the fashion industry. And what we also know today is that fashion law itself has turned into an academic subfield and of media interest as well, if we look at some Instagram accounts that are even monetized today and really have the occupation to examine cases of counterfeiting. As a conclusion, Vionnet, whose brand is represented here on the left-hand side, Vionnet had pioneered intellectual property in fashion firms. Some of her successors, and here you can see on the right-hand side, the brand of one of Vionnet's direct successors, Jacques Griff, which indeed prints the thumbprint that Vionnet used to do herself. This is an interesting continuation on the brand. Successors like Jacques Griff, for example, and many others, adopted similar ideas, sometimes with different media, as we can see here. Vionnet, as we saw, did not entirely succeed in the United States, but Dior succeeded there with a new system of brand licensing. From Vionnet to Dior, however, the structure of the haute couture firms, and to some extent, the nature of the work itself had changed. We have followed in the footsteps of the sociology of law to enter the courts and to examine the activity of the couturiers and their lawyers in the courts. A new dimension needs to be considered, which is the time of history. Time shows that the methods and the creativity pioneered by Vionnet changed. Not least, they changed with the industrialization of some of the production of the haute couture firm. This last step resulted in a divestment from the idea of the couturier as the author and resulted in a rise of the brand. Thank you.
Wonderful. Thank you so much. That was absolutely just so fascinating and so rich. We're going to hand over in a second to Catherine, who is going to ask questions that have been posed by the audience via the chat. So please, if you have a question, put it in the chat now. I wondered if you could, if I can be cheeky and ask the first question. I wondered, I was really interested to see the cuttings from French papers about the Dior-led case. And I wondered how the American press was covering it.
That's really great. Thank you so much, Rebecca. There is indeed some difference, right? The American press also denounced counterfeiting. And I could not take everything in this talk, but there were American firms that, and that's something you know well through your work, your pioneering work on sports that I've read with great pleasure, and on American entrepreneurs. There were American entrepreneurs who were very keen on what they called American origination, right? And we, of course, have to do them justice. And remember that, no, not all Americans were copy houses. I've shown Maurice Rentner a little bit, and Rentner became a champion for originality. But to go back to the core of your question about coverage, indeed, the coverage is somehow different. The vocabulary is somehow different. We see Nan Robertson, we see important journalists of the New York Times who are denouncing copying. But there is also an important part of the opinion that thinks that couture should be more accessible, should be less elitist, should be for everyone. And the French press tends to inflate a little bit this as an espionage affair, right? Which is, of course, exciting, but is it entirely fair for Milton, while what he's doing is a bit in the gray zone in the US? So we have for sure an interesting contrast of media views here.
That's fascinating. Thank you so much. Well, I'll hand over to Catherine now, who is going to pose the questions from the audience. So thank you, Catherine, if you want to switch your video on now. So.
Yes, hi everyone, and thank you for that talk. It was really interesting. So yeah, just gonna start off with some questions. Firstly, we have a question from Michael. He says, are the very long terms of protection provided by copyright appropriate for fashion, i.e. 70 years post-mortem?
Hi, Michael. Thank you. This is a fundamental question, the time of protection. And even the couturiers themselves say at times what we need is 6 months, right? Not more. Then the question surges again with more static items. When I talk about time change, what we see is towards the end of this story that haute couture finds a safe haven in luxury. And in the domain of luxury, we have items like Chanel jacket, for example, right, that are timeless. Then we see the ambiguity of Chanel herself about IP, which is also an important agenda to open here. But to go back to your question, indeed, 70 years is not relevant. And there have been movements, including in the US, very important movements saying what we need is a protection indeed, but a limited protection, limited in time. So thank you very much for evoking that. It's of the essence.
Thanks. So next question from Andrew. He says, I'm interested in the current state of copyright in the age of Instagram. Is that considered an extension of brand representation, or is it more of a grey area?
Can you please say this again?
Instagram? Oh, sorry. So it's basically copyright in the age of Instagram. Is that considered an extension of brand representation, or is that sort of more of a grey area legally?
Right, thank you very, very much. This is also, well, opening very, very heated matters right now. Instagram function both ways, right? We can think about Diet Prada, for example, this one great example of a monetized site that functions on denouncing so-called piracy and plagiarism. Now, there are sometimes problems there too. I've seen images on Diet Prada that were dug up and that were certainly 70 years old. So no, it's not necessarily plagiarism anymore, right? It's inspiration. The problem we have is how do we cite in fashion? As historians, we can use the footnote, but as fashion designers, this is extremely challenging, right? To go back to Instagram, it's a complex tool, and the tool itself does not always come with entire rules for every potential use. I think fashion brands have used it extremely well to take the pulse of the consumers, to advertise themselves, right? There are controversies there, but there's also the sheer beauty and pleasure of the medium of Instagram that functions very well. And then there are also the questions of interpretation and all the debates. There have also been debates about appropriation, for example, that are sensitive. So Instagram indeed is going to give a lot of work to the lawyers.
Thank you. So next question from Fran. I think it was more about sort of your background. How much experience do you have with advising legal documents in relation to your research? And did you find it difficult to adjust to the language used in legal archives?
Thank you so much. This is a very, very important question. And questions of methodology are fascinating. So my training is as a historian, first and foremost. I can say I have a sympathy for all paper, and I encourage everyone to develop the same sympathy. But I also think we need to look at the dresses. Maybe this talk was not a very good example, but it's also important to go back to the object. I was very fortunate when I was writing this research to visit a great number of exhibitions on Dior, on Vionnet, permanent collections, on any other couturiers that have been very important inspiration, even if they tend to disappear behind the fact that historians like written documents indeed. As historians, we trained, for example, to deal with these minute scriptures that sometimes yet can generate some stress when we face the pile of archives. We also are trained to find a way through the maze of these ledgers. For example, I was surprised of the frequency of the lawsuits that I found, of their repetition. And digging through a larger amount of material helped me enormously. As far as the language is concerned, it's very important for multidisciplinary history to approach the texts with humility, to talk to practitioners. I was also very lucky to talk to lawyers at times, to go listen to them, what they have to say. So these things help, but it's been a long-term work.
Great, thank you. So Lauren asks, what happened to the copy houses in Paris after the 1955 lawsuit? Were they all forced to close by that time?
Thank you so much. So in the 1950s, copying was seriously cracked down by the French authorities. So there were still copy houses, of course. And the question is always the firms that work in a gray zone, and there are some, right? So that remains a question. There is, to summarize, a dual movement that's happening in the 50s. On one hand, the couturiers intensify their designer ready-to-wear, including at home, including on the French market. And that's been very well studied also along with the rise of the stylists. I think about several young researchers. I think Alexis Romano also has worked on that, for example, and so on. So the rise of the stylists, the rise of ready-to-wear, designer ready-to-wear, sorry, and at the same time, this movement, notably by the Chambre Syndicale, to really crack down on copyists in France. So many of these firms have to close.
Thank you. There's so many good questions. I'm just probably won't be able to get through all of them. I'm just looking at all of them now. So then this is a sort of broader question. How do you see intellectual property and fashion developing in the future?
Thank you. This is very challenging. There is a question of what's called by some observers the arms race to IP, and the danger is that it can be negative for creativity. A danger of that is that what we could perceive today here is firms that can afford the services of very good lawyers. And a challenge is what happens for the smaller creators. What happens for the small firms? Can they afford lawyers? And fortunately, there are associations that try to represent young designers, and I think this is one of the main challenges. So that not only the big ones can afford to go to the courts. Another question that remains is the derivative character of fashion. How much can we protect without killing creativity?
And a question by Robert, sort of following on from that, what is your view towards visual plagiarism for fashion design, and how is this defined?
Hi, Robert. That's a great question, a great debate. It's very much a case by case. I think it's so important to encourage originality, to encourage young creators. But also, and I think here I want to go back to Vionnet and a minute I found in the Chambre Syndicale archives, where Vionnet was underlining the value of education of young apprentices to design and to drawing after antique, right? And to go back to take inspiration on a much longer time course. So basically to train the eye so as to become able to create.
Yeah, so next question from Rachel. I'm not sure if this is necessarily the period that you look at, but she is thinking about recent cases of lawsuits where large retailers in the 90s were taken to court for copying independent designers. Are there similar instances in the period that you have been specializing in?
Thank you. Yes, absolutely. Absolutely. This is a long history, and there are questions about that. An important part of this history is also how the French regulated the relation between haute couture and department stores. And during the interwar period, couturiers protected themselves by strictly forbidding access to department stores. So that was one way to treat this. Nancy Green, for example, in her fantastic history of transatlantic fashion has discussed that. But that could not last forever. And it was considered by some actors as a monopolistic way to get across the problem. And then this shifted in the post-war era. So this takes us back to the question of giving enough clout to the young designers, to the independent designers, the independent firms. And I think one example we can keep here is the Chambre Syndicale of working together, associating, sharing the costs if there is a problem that arises.
Definitely. So Asha asks, since the Lucasfilm case, the UK court has avoided defining art. How does this lack of definition hurt or help the protection of fashion as artwork?
Hi, Asha, great question. I think the lack of definition of art to some extent can help fashion, because fashion is at the edge, as lawyers Dreyfus and Ginsburg have coined. I think this is a very important concept, to keep seeing fashion at the edge of art and commerce. That's what is making it so difficult. That's what is making it also so rich. And we see towards the end of the talk today that maybe commerce takes over with the licenses and so on. And that indeed not defining helps. And I mean, what could be boundaries for art, right? There we go.
So next question, sort of following on from that. I was wondering how these legal strategies may have contributed to emphasizing the artistic essence of the couturier's work. Were artists using similar protection for their work within the art market in the 20s or 50s?
Thank you. This is a really, really fantastic and really helpful question. Right now, I have engaged in this ERC project where we compare fashion and music, because music is also problematic, but in a very different manner. One point that's challenging us and my group of researchers here is that music has completely dematerialized its medium, but not fashion, right? And so we are trying to go further and contrast. For the fine arts, we see a lot of common points with fashion, indeed. And we think also about textile arts and frontiers and boundaries there. I think one important point that maybe a point for separation, for reflection, for discussion is the reproducibility. Going back, if you will, to theories by Walter Benjamin and saying that we have different problems according to the degree of reproducibility. But we can also think about all kinds of fakes, right? Fake painting also matters here. I saw that a person is asking me to share the bibliography slide. Is it something I may do?
Yeah, we could do that. Sort of maybe, yeah, you could put it up now. If I think there's quite a few people have been asking about.
I will try to do that. There you go.
Yeah, I think that should be fine, because we can still ask questions if people want to have a look at that for a few minutes. And
you still manage, Catherine?
Yeah,
you're doing a great job there, directing the questions. Thank you.
I know there's so many questions. So yeah, I think we've got we've got plenty of time. So we've got a question from Rihanna. How long does it take roughly to train and work and specialize in fashion and fashion lawsuits? What would your be advice into entering into this field?
Hi, Rihanna. All right, so I'm not a fashion lawyer, right? I'm a historian, different kettle of fish. But I think this would typically take a law degree and then a specialization. I have indeed several good colleagues and friends who have taken that way. And so they just keep going after their law studies and just build their culture, right? So typically this is the law career that takes that branch. There are entire careers building in this direction. And all the large fashion and luxury groups these days have a law division. Sometimes smaller branches may borrow the law specialists of the mothership. But if we think of a firm like LVMH, for example, they have a full office of lawyers that work there on thorny questions day in, day out.
Thank you. Bridget asks, can you tell us any more about the relationship of Dior and Boussac?
Oh, thank you. This is really great. If you cannot get across this, the book by Marie-France Pochenat, Bonjour Monsieur Boussac, is rather funny about that, and is telling a lot. It's a more, at times, anecdotal form of book, but it no less has great value. Boussac is really looking for a young, up-and-coming, bright creative designer when he hires Dior. And Boussac is really holding the purse, right? So Boussac's idea is, I will give you the means and freedom to create with peace of mind. And that's really what Boussac is capable of offering Dior. In exchange, Boussac also offers Dior an excellent manager with Jacques Fath, who will last much longer than Dior. Dior lasted 10 years on the job and then unfortunately died of heart malfunction. And Boussac went on for several decades, holding the administrative reins of the couture house. Boussac and Rouet met every week without Dior, right? So there's a lot of the management that goes on at a different place. But Dior gives his name to the brand, and Dior creates at a frantic pace for this house.
Thank you. So interesting. Michelle asks, did French fashion houses sue any companies in London? So kind of was this happening in London as well as in the US?
Thank you. This is a fantastic question. I think you will have to do the research because I have not found cases in the French archives about London companies. I have found cases of Belgian companies, and you know, I'm a Belgian, so I felt a little bit responsibility on my fellow Belgians' behalf there for behaving so badly, but there should be cases. Probably there are cases. So there's more work to do, definitely. It would be really fascinating to see other national or other bilateral cases there.
Brilliant. So Victoria says, what do you think are the fundamental, I know we've kind of had similar questions in this vein, but what are the fundamental differences between art law and fashion law? And do you feel that one is protected better than the other or not?
Thank you. Thank you so much, Victoria, for this question. I think that fashion adds some layers of difficulty here, and I should have added them to the bibliography here. Jane Ginsburg and Rochelle Dreyfus have written about that, using this concept of the works that are at the edge between art and commerce, and explaining that these also test the frontiers of the law, they test our understanding of the boundaries. Here with fashion, what we see that is particularly interesting and challenging is this difference between France that protects it more and the American system that protects it less. The view of political economists about that is that national interests are of the essence. So that since France has a thriving high fashion industry, France will indeed reinforce not only case law, but even the complete legal landscape in order to support this high fashion industry, while a country like the US historically had built as a manufacturing country. And then we can also imagine this question moving along with new frontiers for fashion production, thinking about how now China has worked quite a bit on its IP law, because the Chinese themselves have amped up engineered production, have amped up innovation in technology and so on. So the idea is that when the countries become more innovative, become leading innovators, then they reinforce their intellectual property law. So we have this political economy of law, law as, in a sense, as a trade protection, right? That is really important to keep in mind. As far as art is concerned, there also are extremely important problems in terms, for example, of what's follower pride, droit de suite in French, which is what happens when a work is resold, for example. How do we protect it? How do we protect the work from not being distorted, right? So even if the work of art can seem less problematic, it not necessarily is. Here, I would really, really advise you, if you haven't had the chance to read this extraordinary book before, to read Nancy Troy's Couture Culture, where she explains the parallel between Marcel Duchamp's ready-made, the birth of the ready-made art, and what happens in couture. And Nancy Troy's work is extremely foundational and quite fun to read as well. So, so I think that would really help go forward there and think about the work of art in parallel.
Thank you. I think we maybe got time for one more quick question. Quite a few people are asking this. I'm not sure if it's necessarily answerable that easily, but how should young designers or student designers move forward in hoping to protect their work? You know, as we've kind of touched on this a bit, but yeah, young, small designers versus, you know, big fashion houses.
Mm-hmm. For young designers, I think that there is one great news, which is that I hear brilliant scholars in the field of fashion law who are very preoccupied by their future and very interested in how they can build robust protection. How is it possible to think about encouraging creativity from the bottom up, encouraging creativity at the grassroots? And I think indeed, in these times of concentration, of large production, of winning companies building the path, it's important to remember that if we don't reinforce protection at the grassroots, we're going to have also people who get disappointed in developing their creativity. And so that's something to keep in mind. There are more and more associations as well that try to help young creators with law, try to help share the costs and so on. So this is also important. I think it's important to build portfolios and to enter the industry being aware of the resources. And I think here I see also schools that are really making new tools available more and more, that schools are making a great work in making this available to new entrants in design.
Thank you so much. Yeah, I think it's past now, so I think that's all we have time for question-wise, but that was so interesting, and thank you for your talk, and thank you everyone for the questions as well.
Thank you very much. Catherine, you did a remarkable job.
Thank you, I tried my best.
Thank you very, very much. That was wonderful. I think you can hear me even if you can't see me. Thank you so much. Thank you, Véronique. And remember that her book is coming out in May, titled Paris to New York, the Transatlantic Fashion Industry in the 20th Century. And that's from Harvard University Press. Thank you so much for such an inspiring and wonderful talk, and for answering all of the questions so carefully. Thank you to everyone for coming. One small point, the person who asked about getting into fashion law, I actually have a wonderful former fashion history student, MA student, who then did a law conversion course and is gradually working her way from that direction, from fashion history to fashion law. So a shout out to Barbara, who is brilliant and we hope will become a fashion lawyer very soon. So thank you so much, everyone. Have a lovely afternoon, and we hope you can join us at the next Documenting Fashion event. So thank you, Veronique. Thank you, everyone. Bye-bye.
Thank you. Bye.